Someone asked me, how do I know if I have a case? I told them, you need to IRAC your facts. So I am going to show you how to do that. The first thing you need to do is know your facts, because you are going to look to these facts to IRAC your case. Now, in previous videos, I talked about 3 levels of facts. You have your material facts, your relevant facts, and then you have those facts that help you to tell the story. So what I am asking you to do is write down all of those facts. And you can come back later on and determine which ones are material, which ones are relevant, and which ones you need to just tell your story. Okay? Look to your facts. Critical. So let's identify the acronym IRAC. The I stands for issue, R, rule of law, A, analysis, C, conclusion. Issue. What discriminatory activity took place on your job against you? Which protected area are you suing under? Race, religion, disability, age, sex, national origin? So for the purposes of this demonstration, I want to use retaliation. Retaliation usually comes with a discriminatory complaint based on one of the protected areas under Title VII. So let's look at employment retaliation as the issue. So the next letter in the acronym IRAC is R, rule of law. Now we need to know what is the law on retaliation. Let's see. To establish a prima facie case for retaliation, the plaintiff must show 3 things: that there was a protected activity, an adverse action, and a causal connection. Now it's time to analyze the facts and the law. Remember, we said earlier in this video, look to your facts. So the question becomes, does your facts support using the law that you select to use? Also, look to the law. Does the law support using the facts you choose to use? So let's look at this more closely. So let's look at the elements to make a prima facie case for retaliation. We're still on the A in IRAC, which stands for analyzing. The first element, protected activity. Were you engaged or did you participate in a protected activity? Are these facts? Is this information in your facts? Protected activity, for example, did you complain? Did you verbally complain? Did you make your complaint in writing. That would be an example of protected activity. Is there any language in your facts that show you participated in protected activity? If your facts do, then so far you have shown the first element. The second element: was there an adverse action taken by your employer? After you complained, for example, were you terminated? Were you written up? Did your job duties change drastically? Those kinds of things are suggestive that an adverse action was taken against you. Again, if your facts demonstrate this, then you have met the second element. The third element: causal connection. Time. How close in time was the adverse action and protected activity? Let's say that the plaintiff complained and 7 days later the employer wrote the employee up. The closer the time the adverse action is to the time the employee complained, the protected activity makes a strong inference of retaliation. Now, of course, the court looks at other things than just the time, but the time is critical in determining retaliation. So if your facts include information establishing that the adverse action occurred 7 days later after the protected activity, then you have established a prima facie case for retaliation. By this time, the law and the facts have spoken. Conclusion: that's the C. In IRAC, you have analyzed your case using the IRAC method. Follow the results. If the results say your case do not have merit, it doesn't. If the results say your case has merit, then move forward. Lastly, remember to write your complaint with the 12B motion to dismiss defenses in mind. I did a video on that. Go down the Federal Rules Civil Procedure Rule 12 checklist and make sure that your complaint is in compliance. You want to cut the defendant off. And even if the defendant files a motion to dismiss, you can defeat it. Get a head start. Okay? Until we meet again, Advocate Lucinda, be empowered.